This is the story of the one. As head of maintenance at a concert hall, he knows the show must always go on. That's why he works behind the scenes, ensuring every light is working, the HVAC is humming, and his facility shines. With Grainger's supplies and solutions for every challenge he faces, plus 24/7 customer support, his venue never misses a beat. Call quickgrainger.com or just stop by. Grainger, for the ones who get it done.
What's the easiest choice you can make? Window instead of middle seat? Picking a vendor who sends a great gift basket? Outsourcing business tasks you hate? What about selling with Shopify? Whether you're selling a little or a lot, Shopify helps you do your thing, however you cha-ching. Shopify is the global commerce platform that helps you sell at every stage of your business. From the launch your online shop stage to the first real-life store stage, all the way to the did we just hit a million orders stage. Shopify's there to help you grow. Whether you're selling scented soap or offering outdoor outfits, Shopify helps you sell. Wherever and whatever you're selling, Shopify's got you covered. Sign up for a $1 per month trial period at shopify.com/try. Go to shopify.com/try now to grow your business, no matter what stage you're in. Shopify.com/try.
With your host, Andrew Donaldson. This is Heard Tell.
Welcome back to Heard Tell. This is going to be fun because this is a kind of an old story in law, but a new twist on it. We're going to go out to Arizona, another great Young Voices contributor. She's a professor of law out at the University of Arizona. That'd be the Wildcats, not that other one that does Sun Devil type stuff. Jane Bambauer, how are you, ma'am?
I'm doing great. How are you?
Feels like Arizona out here. It's a nice hot day out here on the East Coast for a change of pace. Summer's sneaking up on us. We're doing well, ma'am. Interesting thing. You've been writing in the Washington Post about letting police access Google location data can help solve crimes. Now, we've seen this pop up a couple times. We've seen it with the in-home technology. We've seen it with data location, things like that. You've kind of got a new twist on it here. I'll just set it up and let you tell the story, but are we going to really let Google start solving crimes? And is that a good idea? And give 2 examples, Professor.
Give 2 examples. Okay. So I wouldn't say that generally in all applications, it's a good idea to have law enforcement knocking on the door at Google or Apple or any other tech company and getting whatever they want. This case, the reason I decided to write about it is because it's an inversion of the usual way that police investigate crimes, and that matters a good deal. So let me tell you what happened in this case, and then I can explain why I think it's so different from the other style of data access that police usually get. So in this case, a man walked into a bank. He shielded his face using his smartphone from the security cameras. So the police knew that he used an Android device, which wound up being helpful. He went into a bank, he robbed it, got away. And the police tried to figure out who he was, the sort of ordinary ways, asking witnesses and trying to follow up leads, and that didn't go anywhere. So then they applied for what's become known as a geofence warrant. They went to a magistrate judge. They said, okay, we know that a robbery took place at this location at approximately this time. We would like Google to share with us some location data on anyone who had an Android phone that was within 100, I forget if it's 100 meters of the bank during this 1 hour time period. And so then Google gave them some data. Using that data without any names on it, the police figured out that there were three phones that might potentially be the robber, and they asked for an additional hour's worth of location data of those 3 devices. And then once they got that data, they were able to home in on one phone that matched the other facts that they knew about the crime. And so then they asked Google to identify that one phone users, and that led to the arrest and eventual prosecution of this defendant, Chatry. So the court had to decide whether that process that I just described was a violation of the Fourth Amendment, whether it complied with, whether there needed to be a warrant with probable cause, and if so, whether that style of investigation met those conditions. And the court decided no, that it was a violation of not just the defendant's rights, but all of the 18 other people whose phones happened to be in the vicinity within that hour and whose data was provided to the police.
Now let's get some of the nomenclature just real quick, just to make sure everybody's on the same page, because we have a lot of internet lawyers. What does the Fourth Amendment actually do and do not say? I know we could, teach a whole semester or 2 or 3 or 4 years on the Fourth Amendment because it's one of the more contested things that's always getting tried in case law. But just basically, what does the Fourth Amendment give the average American in the average situation as far as protection from search?
Great. Okay. So the Fourth Amendment promises that we all have a right to be free from unreasonable searches and seizures, and that a warrant can only be issued if the police have probable cause to believe that the person that they're investigating, that they're searching, was engaged in crime. So the word search and seizure, for that matter, both of those words have become terms of art, because they don't just mean anytime the police is observing something, that we might call that colloquially a search, but it doesn't necessarily count as a search under the Fourth Amendment. So police can, they can walk down the street and they can look at, they can even follow people, and they can be very interested and intentional about observing a target. And if they stay in public, that's not going to count as a search. So one of the things that this case raises is whether asking for the data from Google even counts as a search at all. And if it does, then we have to ask whether it was an unreasonable search. And then if it was, then it would require a warrant.
Right. So now, to make sure we get the rest of the nomenclature right, the geofencing concept, which it comes under a couple different terms, though, is basically, instead of having one name on a warrant, which is what people traditionally think of, you go to the judge or the magistrate or whatever, and you get, hey, this person, and here's why, here's probable cause, so-and-so. They're saying, well, here's probable cause. We need to look at an area or a group of people or a group of devices. This is kind of a different way of looking at this, right?
Yeah, exactly. So we know that the police will need a warrant if they have a suspect and they want to go search his home, for example. That's the kind of textbook case of when a warrant is required. You can't just walk into a home and look around for evidence. We also now know, thanks to a recent Supreme Court case, that police will need a warrant based on probable cause if they want to go to Google and say, hey, we think Andrew committed a crime recently. Give us the last 100 days of his geolocation records so that we can corroborate our suspicion. That in a case called Carpenter, the Supreme Court decided that even though there was some other precedent that made it unclear whether they would need a warrant or not, that amount of sensitive data about who is, about people's whereabouts constitutes a search. It's an invasion of a reasonable expectations of privacy, which is sort of how the court goes about trying to figure out whether a search has occurred or not. It was less clear, though, whether this style of investigation, where you're just getting a little tiny bit of location data about more people, whether that would follow the same logic as the Carpenter case.
Yeah, talking to Jane Bambauer, professor of law at the University of Arizona. Where this starts getting really sticky now is what you just said. This looped in, almost 20 people and their devices. When you're talking about privacy, when you're talking about, reasonable search, now with technology, we have this whole nother layer of it, because this data, they're not going to the people for it. They're going to Google for it. And now you have things like user agreements and consent agreements, that little check box that everybody clicks on and never reads all the things on. That's where this gets really sticky in a hurry, because now we've got multiple layers on top of the traditional warrant process, which is just the state and the individual. Now you got the state and the individual, and you got this corporation over here, and you've got legal boundaries that they've already signed. Where do you even start trying to wade through that swamp when you're starting to try to get a warrant for 20 people's data that they also have a consent agreement with? I don't even know how to ask the question. That's how complicated this is. Isn't that kind of the core of the problem here, though?
Well, yes, sort of. If we start with an attempt to just take as granted everything that the court has ever said about when a warrant is needed and when it isn't, and then try to feel our ways to this case, it's going to be really hard. But I prefer to slice through the cases in a slightly different way. So let me explain why I think that what happened in this case should be allowed, why I think the police should be allowed to ask Google for this type of data, even though they're not allowed to go to Google and say, hey, give us the last 7 weeks of Andrew's data. First of all, it's worth mentioning that police have to do something to get an investigation started. So it's never a question of whether a crime is going to be investigated. The question is how. And so police can, of course, stand on a corner and see what 20 different people are doing. They can see their public movements without initiating anything that counts as a Fourth Amendment search. What might surprise your audience is that what they can also do, with the exception of large amounts of location data, they can also go to any company with a subpoena, so not a warrant, but just a subpoena, which is basically a request. And they can say, hey, give us records, any records that you have about Andrew. They can, in fact, it's actually even worse than that. Let me tell you about this weird puzzle where under the Bank Secrecy Act, banks they're required to keep records on transactions. So if you have a bank account, banks are compelled to keep records, and they also must respond to a subpoena. Again, not a warrant, just a request. And under the Fourth Amendment, all of that can be done without triggering a Fourth Amendment search. So if we think about what police already can do and have been allowed to do based on mere hunches or whims, it's probably quite shocking. That's one reason I think many people, including myself, applauded the Supreme Court when, in the case of Carpenter, they said, no, wait a minute. I know we had previously said that police can access records that are held by a company without it even counting as a search, but this has gone too far. Too much of our lives is now documented in these records that companies hold, like Apple, Google, any of the tech companies. So that's great. But what to me is profoundly disturbing about that subpoena process, where you ask for Andrew's, 7 weeks of Andrew's transaction or location data, is that it starts with a suspect, and there's no duty for the police to abide by any kind of limiting factors in terms of when or how or why they would ask for any one person's records, and then they can go access very sensitive records. By contrast, this case starts with the facts of a crime. And so it is self-limiting in the sense that the police don't actually know who's going to be caught up in the geofence. It could be politicians, it could be, it could be their friends. It's not as useful as a tool for discretion. And for that reason, I think we should not treat all access to data under the same umbrella. We should think carefully about how we want police to solve crimes. In fact, even in this case, the police first tracked down 2 leads that turned out to be wrong. One of the leads was that a woman called the police department and said, my ex-boyfriend so-and-so must have committed this robbery. And, it's not clear from the opinion what the police did to figure out whether that was true, but it turned out not to be true. And so that's an example of an individual totally innocent who wound up getting trapped up for at least a little while in a police investigation. And that's terrible, but it's also just part of what happens necessarily with police investigation. Another lead involved a bank employee who knew somebody who drove the type of car that was used as the getaway vehicle or something that was suspected to be involved in the crime. And so it was just the right make and model and maybe color. There was no other reason to think that this person was involved in the crime. And so the police had to figure out whether that person committed the crime. So the fact that innocent people may wind up being implicated and that's very stressful is unfortunate, but it doesn't make this process any different from, and actually maybe even less, this process might be actually less burdensome to the innocent than the usual traditional style of investigations.
Yeah, and we're going to get into that with Jane Bambauer here shortly. Not only that, but this also cuts into how police investigate and some of the concerns folks about how those investigations work, how that's going to change this. We're going to get into a little bit more of the case law background on this and how this case worked out. More with Jane Bambauer right after this as Her Tale continues. Welcome back to Her Tale. We got Jane Bambauer. She's professor of law at the University of Arizona. She's been writing in the Washington Post about geofencing, which is just a new high-tech version of an old debate that we will have in perpetuity over the Fourth Amendment and warrants and searches and things like this. Let me ask you it this way. You had just touched on the fact that this changes how police view suspect. I found it interesting when you wrote about it. You actually found kind of, I don't know if you'd call a silver lining in this, but in a day and age where we're very concerned about police conduct, police misconduct, we talk about things like police bias. You actually mentioned that if things like geofencing was properly attributed, that this could actually do a little bit better because you're doing things like de-identified data that takes some of the implicit biases out of it. Some of the things that we're very concerned socially about police work, this could actually be a tool if properly used and managed and constrained by law, big if there, but that could be a good thing in some ways because this is just raw data without some of those social things that we're so concerned about, isn't it?
Exactly. The reason I write about on this topic is for precisely the reasons that you raise. I see some forms of technology-driven police investigation as part of the police reform process. So I started in this area deeply concerned about, a few things that all sort of tie in here. For one thing, we have a clearance rate problem where we have these really, really long sentences, in part because police aren't solving enough crime. There's not as much likelihood of detection and enforcement as there are in other countries, and clearance rates actually have gone down in the last few years. So that's a real, so we have a real crime problem, a real potential overpunishment. In my opinion, there's an overpunishment problem. And then at the same time, we also have this potential for expansive access to private data. And so we might at the same time be suffering from privacy violations. So what I see potential in something like a geofence investigation, because the privacy invasion is there, but it's, in a comparative sense, it might be minimal or less bad than other traditional forms of policing. And as you said, it's more constrained to the facts of a crime, and therefore less likely to be an avenue for unintended bias or even for just harassment and abuse of power.
Yeah, talking to Jane Bambauer. One of the great bottlenecks, you're talking about all the problems in the legal system. One of the great bottlenecks in the system is pretrial confinements and things like this. Is there a way that some of this data could start being used so that we're not just throwing people into the system while we're still investigating them, that sort of thing? I know that's a little beyond the scope of the geofencing we're talking about, but there are people talking about, hey, if we use technology correctly, because that's really the dirty, sticky end of the legal system right now, where a lot of this bad stuff happens. That's where we start creating criminals instead of solving crimes. Is there a potential for some of this data and technology to start clearing up that end of the legal system where we can maybe have some of this data and not have to just have the whole weight of the court system dealing with every single little thing that's going on?
Yes, yes. So there have been proposals and some increased use in some counties of tracking and monitoring devices in lieu of pretrial detention, and also in lieu of longer sentences. It's also a good probation on the other end of the of the process. It's also a good tool for probation rather than incarceration. And I completely agree with you. One reason arrest is so terrible, so life transforming, is because of the incarceration, that a person is taken away from their job, their family, before they've even been convicted, and oftentimes arrests are of course are done without, arrests don't lead to conviction. And then also, as if that weren't bad enough, we have a well documented at this point problem where jail and prison has this has a criminogenic, as it's called, effect. That is, it produces more crime, and that's partly because people are no longer have the sort of support and jobs and whatnot from the pre-jail life, and there are other likely explanations as well, that when you're forced to associate with people who know how to do crime, it just it can lead to more crime. So yeah, there have been proposals for expanded use of surveillance and monitoring in lieu of incarceration. I'm all for that. There are privacy advocates that see it as dangerous because what starts as a mere substitution could then be broadened, and we might start using, if arrest seems less terrible, it might happen more often, and so that the police can monitor people. I see how there can be some unintended consequences down the line, but for right now, I see so much upside from making that switch that I wouldn't worry until we, get there about downsides.
Now, of course, that is on the suspect end of the spectrum. We've talked about some of the positives that theoretically could come out of this on the law enforcement side of the spectrum of this thing. But Professor, as you all know, that all sounds great on the board in the classroom, but we're out here in the real world. We're grown folk. We understand that human nature is undefeated, and we got a lot of data. The police are human beings, and they like to push the boundaries of their authority. How do we, they're not doing real great with the warrant system as it is in a lot of cases, as we've seen too much in the news headlines lately. How do we realistically constrain things like this? Because of the high-tech nature of this, some of the old models of restraint just aren't going to work. Some of the old check and balances are going to have to be updated some form or fashion, I would think. How do we make sure that the good parts are getting implemented without the bad parts where they can get very invasive into people's lives in a big, big hurry with this technology?
Yeah, great. Yeah, so I think there are a few practical limits that should be applied either by police departments themselves, and that does happen. Police agencies, and certainly the federal Department of Justice often actually constrains itself even more than law would require. But I'm also hoping that this is an area where legislation could fill in and actually take some pressure off of the courts too, to figure out what's allowed and not allowed. The constraints that I think are important, at least at this stage, are, first of all, making sure that a request of this sort is unlikely to capture way too many devices. So, if there's a crime at a Justin Bieber concert, this is not the right tool, right? You're going to have just too many cell phones in a small area, and unless there's some other, unless there's some other limiting factor that can help ensure that only a small number, say, fewer than 50 or something devices are tracked. I have advocated for, it's not super popular, but I've advocated when we have a new technology for limiting its use to the more serious crimes. The thinking there is that it allows a sort of testing and proving ground and figuring out what the problems are in a context where the crime solving, if it does indeed turn out to be efficacious, the crime solving is most valuable to the public. So personally, if I got to design everything, I would limit its use to felonies that are punished at a certain level, maybe not even all felonies. The other thing I worry about is, as I said before, I think one of the benefits of this style of investigation is that there's just not a lot of room for the police to exploit the tool. I mean, unless they're making up crimes whole cloth, and as long as there's some process of confirming that a crime did occur at a certain area and the geofence is constrained enough to not wrap in too many people, it doesn't seem to be as ripe for abuse.
Let's talk about it this way, because we want to bring this to a practical thing. We understand that these things get worked out. We understand one of the frustrating things with technology moving so fast is we actually just have things downtown. It's like, oh, well, I wonder who's the first person to sue so we can get some case law on this is going to be. It's just kind of how the legal system works. What's the legislative side of this? There's obviously a path here where there needs to be some legislative oversight, both on the state and federal level. Municipalities are probably going to have some variations on these things, depending on things. Where do you see that going? Because that too is going to affect the case law, because as we've seen with other things, the motto of the Supreme Court lately has been go talk to Congress about it. Where do you see that going and how that's going to affect the case law? Is there a push for legislation in this area, or is it something that's really, really lagging? And we're going to probably, unfortunately, with the way legislatures work, we're going to have some kind of a bad news event in this area for them to get attention on it.
Yeah, well, the only legislative activity that I'm aware of are legislatures like New York's that are contemplating banning this process entirely. So I think geofencing has wound up being kind of categorized with things like facial recognition technology as something that just has an ick factor, and legislatures feel like it's more politically palatable to just go ahead and cut off police use. In some ways, that's a little bit of a challenge, because if what I'm suggesting sounds right, like if we actually want to encourage some limited use of this style of technology-driven investigation, it's not clear who lobbies for that, right? I mean, the police departments themselves, maybe. But on the other hand, if the police departments think that without legislation, they're basically unconstrained, then they probably won't. So I think, that there's a kind of political economy problem here that I am not really an expert in and could not kind of forecast how this could work out. Let me comment, though, on your observation that the Supreme Court has too frequently hinted that they're just waiting for the legislature, whether federal or state, to get involved. I see that as a trend too, and it's an unfortunate trend. What I see in Fourth Amendment case law, it's always been a little bit of a hodgepodge. I mean, it's just very strange. Supposedly, we're looking at what reasonable expectations of privacy are, but then, police can pretend to be other people and be your friends, and they can do really strange things to get extract information out of you, and then they can't do even the slightest. They can't even touch your doorknob or something. The case law is very strange. It's starting, though, to get to the point where there isn't even a lot of grounding principles. I would love for courts in the lower levels at first, and eventually sort of showcasing their thinking as cases move up to the Supreme Court, to come up to articulate the core values that we're trying to preserve, and how how the legal system should balance them against the practical necessity of police investigations. And I just don't see a lot of that. Even Carpenter, the case that we were talking about, where the Supreme Court decided you can't go get 100 days worth of geolocation data, the Supreme Court wouldn't even say how many days of geolocation data you can get without a warrant, right? So their decisions these days have been so narrow. They're sort of gesturing toward thinking that there's too much privacy abuse, but are not giving us firm principles to kind of iterate on.
We're going to have you back on, because I really want to talk about this at some point with one of our legal experts like you or one of our other friends. It's gotten to the point, what we're talking about with the case law. We now have states specifically writing legislation to get it into the Supreme Court. I think that's a very pro or against or whatever that's a really bad, that's not a good path we're going down with that. We'll have you back and talk about that in a water sense, because when you start having the participants in the system trying to short circuit the system, that never ends well. But that's another topic for another day. Jane Bambauer, outstanding stuff on the Fourth Amendment, geofencing, technology, trying to keep up with case law. Appreciate your time today. We're going to definitely have you back, but until we get you back, let folks know where they can follow you, your social media, where you're writing at. This piece we're talking about, again, was in the Washington Post. We'll link to it in the show notes, but let folks know what you have going on until we see you again.
Yeah, okay. My Twitter handle is @Jane Yakowitz. That was my maiden name. And you can always find out what I'm up to via the University of Arizona's website and my faculty profile. Thanks. It was great.
Yeah, Jane Bambauer and Yakowitz, that's pretty much a law firm right there. So, it could have been something. Jane Bambauer, professor of law at the University of Arizona. Thank you so much. Can't wait to talk to you again. Yeah, I think we should dig into that. That's something that I think not very many people are talking about, but it's going to really dictate some things over the next 5-10 years, I'm afraid. You tell me if I'm wrong, but I see that train coming and I don't like how it looks. I don't know about you.
Yeah, no, I agree. It's not a good trend.
Yeah. Go ahead.
Well, I was going to say, I think some of the state laws, like in terms of abortion restriction laws and stuff like that, some of the state laws are designed to test whether there's the Supreme Court is ready to make a change of rule. That has its own perverse consequences. But another problem, which I think you're right is related, but I can't, I haven't thought through how, is this increasing narrowness of the way that the Supreme Court drafts its opinions. So it used to be that the Supreme Court would write short opinions, like 20 to 40 pages long, and they'd have these kind of overarching explaining their overarching values so that lower courts could try to apply them to new facts. Now the opinions are hundreds of pages long, and they just say, well, we're not going to say much more than just that this case is decided in this way. And we haven't, we reserve the right to decide a different way for almost any other case. And it's really an abdication of their responsibility.
Yeah, the Roberts Court is going to be a fascinating study 20, 30 years from now in a lot of ways. Jane Bambauer, thank you so much for the time today, ma'am. You were great. Appreciate it.
Yeah. Okay.
Thank you.
This is the story of the one. As head of maintenance at a concert hall, he knows the show must always go on. That's why he works behind the scenes, ensuring every light is working, the HVAC is humming, and his facility shines. With Grainger's supplies and solutions for every challenge he faces, plus 24/7 customer support, his venue never misses a beat. Call quickgrainger.com or just stop by. Grainger, for the ones who get it done.